This YouTube channel is intended for educational and informational purposes only. The content shared on this channel reflects the creator's personal journey of learning about U.S. laws, the Constitution, and related topics. The information presented should not be considered legal advice, nor does it substitute professional legal counsel. While every effort is made to ensure accuracy, laws and legal interpretations may change over time. Viewers are encouraged to conduct their own research and consult a qualified attorney for specific legal concerns. The opinions expressed on this channel are those of the creator and do not necessarily reflect the views of any organization or institution. By watching and engaging with this content, you acknowledge that value freedom is for educational discussion and exploration, and you assume full responsibility for any actions taken based on the information provided.
What is freedom of religion in the U.S.? Freedom of religion in the U.S. is a fundamental right protected by the First Amendment of the Constitution. It guarantees two key principles. The Establishment Clause: the government cannot establish an official religion or favor one religion over another. The Free Exercise Clause: individuals have the right to practice any religion, or none at all, without government interference, as long as their practices do not violate laws that apply to everyone. This means people are free to worship as they choose, express religious beliefs, and organize religious groups without fear of persecution. However, religious freedom does not allow actions that break general laws, e.g., human sacrifice or discrimination under the guise of religious belief. What are some examples of when freedom of religion is threatened in the U.S.? Freedom of religion in the U.S. can be threatened in various ways, including government restrictions on religious expression, laws or policies that limit religious attire, symbols or speech in public spaces or workplaces can infringe on religious freedom. For example, attempts to ban religious head coverings in certain professions. Zoning laws against religious institutions. Some religious groups face difficulty establishing places of worship due to restrictive zoning laws or community opposition, effectively limiting their ability to practice their faith. Discrimination against religious individuals or groups. People may face discrimination in workplaces, schools, or public spaces due to their religious beliefs or practices, such as being denied employment opportunities because of religious dress or prayer practices. Forced participation in activities against religious beliefs. Some individuals or businesses argue that being required to participate in certain activities, e.g., providing services for events that conflict with their religious beliefs, violates their freedom of religion. Courts have debated the balance between religious freedom and anti-discrimination laws. Targeting of religious groups, hate crimes, vandalism of religious institutions, or government surveillance of specific religious communities can threaten religious freedom. Limitations on religious practices, laws that restrict religious ceremonies, dietary laws, or other practices, e.g., limits on ritual slaughter or circumcision, can interfere with religious traditions. These issues are often debated in courts, where the balance between religious freedom and other legal rights, such as anti-discrimination laws, continues to evolve. How can employers infringe on freedom of religion? How can employees defend their religious beliefs from being infringed? How employers can infringe on freedom of religion? Dress code restrictions, prohibiting religious attire such as hijabs, yarmulkes, turbans, or crucifixes without a valid safety or business necessity. Prayer and religious observance restrictions, not allowing employees time or space for prayer, religious study, or other observances. Scheduling conflicts, requiring employees to work on religious holidays or days of worship without offering reasonable accommodations. Workplace discrimination or harassment, creating a hostile environment by allowing religious harassment or discriminating in hiring, promotions, or assignments based on religion. Forcing participation in religious or non-religious activities, requiring employees to engage in activities that conflict with their religious beliefs, such as company events that contradict their faith. How employees can defend their religious beliefs. Know your rights. Under Title VII of the Civil Rights Act of 1964, employers with 15-plus employees must provide reasonable religious accommodations unless it causes undue hardship. Request accommodations. Employees can formally request religious accommodations for dress, prayer, or scheduling. Employers must consider these unless they significantly disrupt business operations. Document everything. Keeping records of requests, responses, and any discriminatory behavior can help in legal disputes. Seek HR assistance. If religious rights are being violated, employees should report concerns to Human Resources. File a complaint. If internal resolution fails, employees can file a complaint with the Equal Employment Opportunity Commission, EEOC, or take legal action. Employees have strong legal protections, but they should balance their rights with workplace policies while advocating for fair treatment. What are examples of government restrictions on freedom of religion and religious expression in the U.S.? There have been several instances where government actions have been seen as restrictions on freedom of religion and religious expression in the U.S. Some examples include restrictions on religious symbols, dress, public schools, and workplaces. Some government institutions have attempted to restrict religious dress, such as bans on hijabs, yarmulkes, or crosses in public schools or government jobs. Prison and military. Culture trot shanastao jarashes. Codes. Policies limiting religious beards, head coverings, or attire have led to legal battles over religious freedom accommodations. Zoning and land use restrictions, blocking the construction of religious buildings. Some local governments have used zoning laws to prevent mosques, churches, or temples from being built, often under the guise of community concerns. Religious schools and institutions facing barriers. Certain religious schools have been denied accreditation or funding due to their religious teachings. Prayer and religious expression in public spaces. School prayer bans. While students are allowed to pray privately, school-led prayer and religious activities in public schools have been ruled unconstitutional, which some argue restricts religious expression. Religious displays on government property. Courts have ruled against displaying religious symbols, such as nativity scenes or Ten Commandments monuments, on government property, arguing it violates the Establishment Clause. Restrictions on religious practices, laws against religious ceremonies or practices. Some laws have restricted animal sacrifice, affecting Santeria and other faiths, peyote use for Native American religious ceremonies, and kosher, halal slaughter methods. COVID-19. Worship restrictions. During the pandemic, some state and local governments imposed stricter restrictions on religious gatherings than on secular businesses, leading to legal challenges. Government mandates that conflict with religious beliefs, healthcare mandates. Some religious organizations objected to government requirements, such as providing birth control coverage under the Affordable Care Act, arguing it forced them to violate their beliefs. Business owners and religious expression. Cases like Masterpiece Cake Shop vs. Colorado Civil Rights Commission have debated whether religious business owners can refuse services, e.g., making a cake for a same-sex wedding, based on their beliefs. While the U.S. Constitution protects religious freedom, these issues often lead to legal disputes over the balance between religious rights and other government interests. What are examples of zoning laws put into action against religious institutions? How did the laws affect the religious institution? What are some examples of when a law threatens freedom of religion and the law is declared unconstitutional, struck down, or rendered void? Examples of zoning laws against religious institutions. The Islamic Center of America in Dearborn, Michigan. The Islamic Center faced difficulties due to local zoning laws in the early 2000s, which made it challenging to build and expand their mosque. Local residents voiced opposition, citing concerns about traffic and the size of the building. In response, the mosque fought against the zoning restrictions, and a legal settlement was reached that allowed the center to expand. This example illustrates how zoning laws can be used to restrict the growth or establishment of religious institutions, especially in areas with high resistance to certain faiths. The Brooklyn Tabernacle, New York City. The Brooklyn Tabernacle, a large evangelical church, faced zoning challenges when it attempted to expand its worship space in a neighborhood where the local government had set limitations on religious institutions' ability to operate within certain commercial zones. This hindered their ability to expand, forcing them to engage in prolonged legal battles. The church eventually found a way to expand, but this situation highlighted how zoning laws can create barriers for religious institutions in urban areas. The St. John's Catholic Church in San Francisco. In the 1990s, St. John's Catholic Church in San Francisco was denied permission to expand its church and facilities due to zoning laws and concerns about preserving the aesthetic character of the neighborhood. The church had to navigate a legal process to resolve the dispute and gain approval for its expansion. This case highlights how zoning laws may be used to restrict the physical growth of religious institutions, especially in areas with significant local opposition. How zoning laws affect religious institutions. Zoning laws that restrict or prohibit the establishment of religious buildings, places of worship, or religious schools can limit access to religious services. Congregants may have to travel further, reducing the convenience and accessibility of their place of worship. Prevent expansion of religious communities. Growing religious communities may struggle to find appropriate locations to accommodate worshipers. Create financial strain. Legal battles or compliance with restrictive zoning laws can drain resources and delay construction or operation, affecting the financial stability of the institution. Examples of laws threatening freedom of religion and being declared unconstitutional. Employment Division versus Smith, 1990. In this landmark case, the Supreme Court ruled that a state could deny unemployment benefits to two men who were fired for using peyote as part of a religious ceremony, stating that the state could enforce laws against drug use, even if it burdened religious practice. This decision threatened religious freedom by allowing the government to override religious practices without proving a compelling interest. Result, after public outcry, Congress passed the Religious Freedom Restoration Act, RFRA, in 1993, which reinstated stronger protections for religious practices by requiring the government to meet a strict standard before infringing on religious freedom. Burwell versus Hobby Lobby Stores Incorporated, 2014. Hobby Lobby, a privately owned business, challenged the Affordable Care Act's mandate that employers provide contraceptive coverage in employee health plans, arguing it violated the religious beliefs of the owners. The court ruled in favor of Hobby Lobby, stating that the mandate violated the Religious Freedom Restoration Act. Result: this decision raised significant concerns about religious freedoms being used to justify denying employees access to certain health services, but it was upheld in favor of the business owner's rights. Town of Greece versus Galloway, 2014. In this case, the Supreme Court ruled that the town of Greece, New York, could open its town board meetings with prayer, even if the prayer was predominantly Christian, stating that it did not violate the Establishment Clause of the First Amendment. Result: the decision sparked debates over whether government endorsement of religion through prayer in public meetings violated the principle of separation of church and state. Masterpiece Cake Shop versus Colorado Civil Rights Commission, 2018. A Christian baker refused to create a wedding cake for a same-sex couple, citing religious beliefs. The Supreme Court ruled narrowly in favor of the baker, stating that the Colorado Civil Rights Commission had shown hostility toward his religious beliefs. The ruling focused on the specifics of the case but did not provide a broad ruling on religious freedom and anti-discrimination laws. Result: the case highlighted the tension between freedom of religion and anti-discrimination laws, but did not fully resolve the larger issue of religious exemptions from public accommodation laws. These examples show how religious freedom can be threatened when laws or government actions conflict with individuals' or institutions' religious beliefs. In many cases, these laws are challenged in court, and while some are upheld, others are found to be unconstitutional or require modification. How are hate crimes handled in the U.S. when religious freedom is being discriminated unconstitutionally? When religious freedom is being discriminated against in the form of hate crimes in the U.S., the law offers protections under various statutes, and the government typically responds through law enforcement, legal proceedings, and civil rights protections. Here's how such cases are generally handled. Criminal prosecution of hate crimes. Hate crimes targeting religious groups are treated as serious offenses and are prosecuted more harshly than regular crimes. In the case of religiously motivated hate crimes, there are federal and state laws designed to protect religious freedom. Federal law. Under 18 U.S. Code Section 247, the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act provides for the prosecution of hate crimes committed because of the victim's religion, as well as other protected categories like race, ethnicity, gender, or sexual orientation. This federal law allows the Department of Justice to pursue charges when a crime is committed based on religious animus. If a crime is committed at a religious institution, such as a church, mosque, synagogue, etc., or if it involves religiously motivated vandalism, arson, or assault, federal prosecutors can step in and charge the perpetrator with enhanced penalties due to the religious nature of the crime. State laws. Many states have their own hate crime statutes that include protections for religious groups. State-level prosecution typically focuses on crimes like vandalism, assault, or threats, where the motive is religious hatred. State laws often provide additional penalties for crimes motivated by religious bias. Civil rights protections for victims. Victims of hate crimes motivated by religious discrimination can also pursue legal action through civil lawsuits in addition to criminal prosecution. Religious discrimination in employment and public services. If a hate crime is tied to religious discrimination in a specific area, e.g., employment, public services, housing, individuals can file complaints under the Civil Rights Act of 1964, Title VII, or other anti-discrimination laws that protect religious freedoms. For instance, if an employee faces harassment or violence because of their religious identity, they may file a complaint with the Equal Employment Opportunity Commission, EEOC. Legal recourse for victims of religious hate crimes. Individuals who experience religious hate crimes may also file lawsuits against those responsible for their harassment or harm. This can include suing for damages related to emotional distress, loss of property, or bodily injury caused by the crime. Law enforcement and hate crime reporting. Local law enforcement agencies, the FBI and the Department of Justice, DOJ, all track and investigate hate crimes. The FBI's Hate Crime Statistics Act, 1990, requires the collection of data on hate crimes, including those related to religious bias. Religious institutions, such as churches or synagogues, are encouraged to report incidents of hate crimes or discrimination, and law enforcement takes these reports seriously. Religious freedom. Advocacy groups. Many organizations, such as the Anti-Defamation League, ADL, the American Civil Liberties Union, ACLU, and the Becket Fund for Religious Liberty, advocate for the protection of religious freedoms and assist in the legal defense of individuals facing religious discrimination. Constitutional protections and legal remedies. In cases where government actions or laws infringe on religious freedoms in ways that could be seen as unconstitutional, courts will examine whether there has been a violation of the First Amendment, freedom of religion. If religious freedoms are being unlawfully restricted, legal challenges can be made to stop discriminatory actions. For example, if an individual faces harassment or violence due to their religious beliefs, they may file a lawsuit alleging a violation of their constitutional rights, invoking the Free Exercise Clause and Equal Protection Clause of the 14th Amendment. Examples of handling hate crimes with religious discrimination: the 2015 Charleston church shooting. Dylan Roof targeted African American worshipers in the Emmanuel African Methodist Episcopal Church in Charleston, South Carolina. This was a clear case of a religiously motivated hate crime. Roof was convicted on federal charges and sentenced to death. The 2018 Tree of Life Synagogue shooting. A gunman targeted the Tree of Life Synagogue in Pittsburgh, Pennsylvania, killing 11 people. The shooting was motivated by anti-Semitic hatred. Federal hate crime charges were brought against the shooter, and the case highlighted how religious discrimination can escalate into violence. In both examples, the victims' religious freedoms were attacked, and the cases resulted in criminal prosecutions under hate crime laws with strong penalties for the perpetrators. In addition, these events led to public discourse on the need for further protections against religiously motivated violence. Conclusion: when religious freedom is infringed upon through hate crimes or discrimination, the U.S. legal system offers both criminal and civil protections to hold perpetrators accountable. Federal and state laws, including hate crime statutes, civil rights protections, and constitutional guarantees, all play a role in defending religious freedoms. Additionally, advocacy organizations often support victims and push for stronger protections in these cases. Within the history of the United States, did the U.S. government try to overturn the Establishment Clause and the Free Exercise Clause? Please state examples and give sources. Throughout U.S. history, the government has occasionally enacted laws or policies that have been challenged as violations of the Establishment Clause and the Free Exercise Clause of the First Amendment. While there have been no overt attempts to overturn these clauses, certain actions have been perceived as undermining their principles. Here are notable examples: school-sponsored prayer and Bible reading, Engel vs. Vitale, 1962. The New York State Board of Regents authorized a voluntary, non-denominational prayer to be recited in public schools. This practice was challenged, and the Supreme Court ruled it unconstitutional, stating it violated the Establishment Clause by promoting religious activity in public education. Abington School District vs. Schempp, 1963. Pennsylvania law required public schools to start the day with Bible readings. The Supreme Court found this mandate unconstitutional, reinforcing the separation of church and state. Religious displays on public property. County of Allegheny versus ACLU, 1989. A nativity scene was placed inside a courthouse in Pittsburgh, Pennsylvania. The Supreme Court ruled this display violated the Establishment Clause, as it endorsed a specific religious message on government property. Funding religious activities. Lemon v. Kurtzman, 1971, Pennsylvania and Rhode Island enacted statutes providing state funding for non-secular subjects in private religious schools. The Supreme Court declared these statutes unconstitutional, leading to the establishment of the Lemon test to determine if a law violates the Establishment Clause. Restricting religious practices. Employment Division v. Smith, 1990. 2 Native American men were fired for using peyote in religious ceremonies and denied unemployment benefits. The Supreme Court ruled that neutral, generally applicable laws not targeting specific religious practices do not violate the Free Exercise Clause. This decision prompted the enactment of the Religious Freedom Restoration Act, RFRA, in 1993 to protect religious practices from such laws. Recent developments. Carson v. Macon, 2022, the Supreme Court ruled that Maine could not exclude religious schools from a tuition assistance program, stating that doing so violated the Free Exercise Clause. This decision reflects a shift towards accommodating religious institutions in public funding. Kennedy v. Bremerton School District, 2022. A high school football coach was dismissed for praying on the field after games. The Supreme Court sided with the coach, determining that his actions were protected under the Free Exercise Clause and did not violate the Establishment Clause. These cases illustrate the ongoing tension and interpretation of the Establishment and Free Exercise Clauses, with the judiciary playing a crucial role in maintaining the balance between prohibiting governmental establishment of religion and protecting individuals' rights to practice their faith freely.